We just started it. Good morning, everybody. Good morning. Welcome to today's webinar. Just give us a few more. I'm going to give everybody a few more minutes to join before we start. But good morning, Daniel, Phyllis, and Sanyam. Good morning, everyone. Good morning, and welcome to today's webinar titled Planning Ahead, How Living Trust Help You Manage Wealth and Avoid Family Disputes. My name is Ogusa Osunde. I'm the Relationships Manager here at Emerging Africa Trustees Limited, and I am very, very pleased to be your moderator for what I promise will be a very, very enlightening and timely conversation. Before we get into the webinar, I would like to know where everybody is joining from. Where are you at right now? Are you on your way to work? Are you on your bed? Are you already in the office? What's going on with you? How's your morning going? Can I see some comments in the chat room? Good morning. Good morning, Martins. Good morning, Ebu. Good. Oh, Zambia home office. Very nice to know that you're in your office. Glad to be here. Thank you so, so, so much joining from the office. Oh, I hope you're having a beautiful morning, every single one of you. Welcome to today's webinar. Like I said, we're going to be talking about living trusts and how they aren't just for the wealthy. They're about planning and preparing intentionally and protecting your loved ones and making transition smoother for future generations. Today, we're going to unpack what living trusts really are, why they matter, and how we can help how they can help you avoid common family conflicts. We're also going to get into real life scenarios and bust a few myths and share practical tips that you can act on immediately after this session. So please feel free to drop your questions in the chat as we go along, and we'll make sure to answer as many as possible. Okay, now let me introduce. Okay, I apologize. I hope everybody can hear me. I hope everybody's hearing me fine and clear. Can I? If you can still hear me.
Press seven up here.
Apologies for the little break, and I'm glad that everybody can hear me. All right, so now let me introduce to you our amazing panelists. First, we have Dami Olupemi, who is a private trust officer here at Emerging Africa Trustees Limited, where he leads the corporate and private trust team. He works very closely with families and institutions on a range of estate planning tools, from living trusts to offshore structures to family foundations and education trust. Dami plays a very key role in our family office services, helping clients think long-term about governance and intergenerational legacy. Next, we have Timileyin Esho, who is a corporate trust officer at EATL. Timmy supports with the setup and execution of both trust structures, capital market arrangements, including bond issuances, escrows, and secured lending. He brings a very highly practical, client-centered approach to wealth protection strategies, ensuring that every detail, or no detail rather, is overlooked when assets or obligations are involved. And finally, we are especially honored to be joined by Olutoye Soni, who is a Deputy Managing Director here at Emerging Africa Trustees. Toye is a seasoned trained lawyer and a trust professional with over a decade of experience across legal practices, project finance, and fiduciary services. Thank you so much, amazing speakers, for being here today. I'm really glad and excited to get into this conversation. I would also like to add that close to the end of the session, we're going to be sharing a very quick 1 minute poll that's just going to help us understand where you are in your estate planning journey. It's very optional, but it's going to help us serve you better. So we really hope that you take out a very quick 30 seconds, a very quick 1 minute from your time to help us to know where you are and support you if needed. All right, so let's get into the questions. To kick things off, Dami, in the simplest terms, what exactly is a living trust and how does it differ from the good old will that parents always talk about?
Thank you so much for having me on this webinar. I'm truly excited to be here, and I hope I am able to share some practical insights that will help the audience think differently and more intentionally about planning for the future. So now, to the question. This is honestly one of my favorite questions because it clears up so much confusion. So at its core, a trust is really just about delegating responsibility and preserving intention. You're essentially saying, I have worked hard to build assets, whether that's land, money, shares, or even a business, right? And I want to put those assets under a structure where someone I trust, called the trustee, will manage, and not just for today, but for the benefit of the people I care about, which we call the beneficiaries. In more professional language, a trust is a legal arrangement whereby a person, which we call the settlor, hands over control of assets to the trustee to hold and manage on behalf of the beneficiaries. So now a living trust takes this even further because it's set up while you are still alive, right? And that means it becomes active immediately. So if a person, or rather if the settlor falls ill or becomes unavailable for any reason, the trust keeps running. So it's really like setting up a relay team where the next runner is already waiting and there's no need for scramble. Now let's compare this to a will, right? Which only takes effect after death. A will is essentially a letter to the court saying, here's how I want my assets to be shared. But now that letter has to go through a process called probate. And this is the process that validates the will and authorizes someone to act on it. So in practice, a will comes with some sort of delays. With a living trust, all of that is bypassed, right? The trustee steps in and simply carries out your wishes. It carries it out smoothly. There's privacy and it happens without delay. I mean, in real life example that we have seen, we've seen an example of someone that both had a will and a living trust. A living trust was really to take care of his assets across different cross-border assets, right? And in the trust, we saw that he gave his appointed trustees a clear framework on how to manage his assets, right? And especially even seeing the scale and whatnot, we could see that with the trust, the assets set aside to manage are without any disputes. Mind you, the will is currently being argued over in court. So here's part of what I really want to emphasize, right? A will ends once the gifts have been distributed, and that's the end, that's the finish line. But with a trust, it can be structured to benefit not just your children or your grandchildren, but even your great-grandchildren all the way to 10 generations down the line. Like a good example is the Rockefeller Family Trust. So with a trust, we see flexibility. To a living trust, we see that it is living, it is in force when you are alive, and it can grow with your legacy. That's the power of trust. It does not just transfer your wealth, it also preserves your vision. Thank you.
Thank you so much, Dami. That was very, very simple, but very clear. Just for the sake of the people that are joining late, welcome to today's webinar. It's titled Planning Ahead, How Living Trusts Help You Manage Wealth and Avoid Family Disputes. As we go along, please just put your comments and questions in the chat box and we'll get to them when the time comes, the Q&A session. Okay, so when most people hear about the word trust, they immediately think it's for the Dangotes or it's for the Otedolas, but this webinar is all about changing that narrative. So Timmy, can you please explain to us why everyday Nigerians or the everyday Nigerian families need to see living trust as something that is for them too?
That's a great question, and you are completely right. A lot of us usually hear the word trust and immediately think it's for the billionaires on Banana Island with multi-billionaire assets and things like that. But of course, it's not true at all. In truth, if you own anything of value, be it land, a shop, savings or investments, or even property, then a living trust is for you. It helps you protect your assets and make sure it goes to the right people in the right way and at the right time. It's really about planning ahead, especially in our part of the world where things can get complicated, extended family pressure, multiple marriages, cultural expectations, and all other things like that. A trust essentially gives you control and clarity. It's not about how much you have, it's about how well you want to plan what you have for the people you care about. Now, why is it important for us in Nigeria or in West Africa as a whole? It's because we live in a region where traditional or cultural practices can be complex, and unfortunately, family disputes over inheritance are very common. In essence, a living trust helps you to put proper structure in place, ensure your loved ones are taken care of without unnecessary disputes, and avoid confusion when they are no longer around. It's not just for the wealthy, it's for anyone who wants peace of mind and order.
Thank you so much, Timmy. That myth that is only for the ultra wealthy really holds a lot of people back, and it's very, very great to hear that living trusts are way more accessible than people think. So coming to you now, Toyi, you've worked across law, investment banking, and trusteeship. So from your unique experience, what is the biggest misconception people tend to have about trusts? Toye, could you please unmute your microphone?
Sincere apologies. I didn't realize it was. Okay, so like my colleagues have said, people often think that trusts are only for the ultra wealthy, the Paris Hiltons of this world. But on the contrary, all you need to be is someone with slightly above modest income, someone with assets to protect on behalf of either yourself or other intended beneficiaries that you love and care about. In fact, a trust could be an effective tool in becoming ultra wealthy to begin with, because when you put all those assets under a trust, you could ensure that they're being managed by the most proficient wealth experts and financial advisors to ensure that the assets under that trust are not just being preserved, but they're actually being grown as well, to ensure that you stay, you become wealthy, and that wealth continues to stay in your family across multiple generations. Um, Again, another thing that people tend to think is that, oh, trusts are too complicated or they're too expensive to set up. And so usually I have to sit down with them and explain to them that really the setup costs of a trust really boil down to the complexities of your estate, the size of your assets or the size of your estate that you wish to put under the trust, the jurisdictions of all the assets you have. So you might have assets, for example, all your assets might just be resident in Nigeria, but you have clients who have assets, in different parts of the world as well. And then, the number of third parties that we might need to, structure this trust properly such that it continues to work efficiently in perpetuity. A trust can be costly, but it can also be quite basic. You can have like a basic revocable trust that is quite affordable. And another thing to consider is that, you have to look at the cost and delays of probate and compare that to the cost of setting up a basic revocable trust. And I find that it's much more financially astute to set up a basic revocable trust. Um, People tend to think that once they create a trust, they lose control over their assets, or that once a trust is set up, the terms or clauses cannot be changed. Again, this could not be further from the truth. A trust can always be set up, giving you effective control over your estate as the settlor or as a co-trustee. A revocable trust, most especially, can always be amended or revoked at any point in time, especially during the lifetime of the settlor. You can always delete or include more clauses. You can always delete or include more beneficiaries to your trust. You can always include or exclude assets that you wish to place under the trust. Some people buy assets even after they've set up the trust. The trustee is not going to prevent you from adding those assets to the trust as well. Some people tend to think that a trust can help them avoid paying all taxes. Once I set up a trust, I no longer have any tax obligations. That is not necessarily true. Most trusts do not avoid taxes by themselves. A trust can offer more tax benefits than if you don't have a trust at all, usually under specific conditions, but they cannot usually eliminate all your tax obligations. Also, the tax benefits that you get from a trust also depend on the relevant tax legislations of the country that you as the settlor reside in, or the jurisdictions where those assets are located. Usually, we would also involve the help of a tax advisor to structure your trust in such a way that it captures the best tax optimization for you as a settlor. Some people tend to think that a will and a trust are synonymous or interchangeable. Some people think that, oh, I have a will, so why do I need a trust? A will already takes care of whatever needs I have as it concerns estate planning or estate management. Yes, I agree that wills and trusts are both tools of estate planning and wealth management, but a trust offers so much more benefits to you than a will. A trust helps you escape the potentially slow and costly and arduous process of probate. A trust also helps to keep details of your estate and your beneficiaries private, and is much more effective as it concerns succession planning and ensuring generational wealth. A will is usually just a one-off thing. Once the testator dies, the will comes into effect, and then once the will is read out and the inheritances are shared, that's the end. That's the end of the will. But a trust can, effectively manage your estate for the next 300 years, ensuring that the wealth in your estate continues to not just be managed effectively, but it continues to grow such that you can provide generational wealth to your, beneficiaries. Some people tend to believe that a trust are only, they only come into effect once you die. Again, that is the case for a will, but that is not the case for a trust. Trust can be useful during your life. They are very effective for managing your assets for yourself as the settlor, or for yourself even as the beneficiary, and for other intended beneficiaries. We have, for example, athletes or music artists who come across a significant amount of wealth, and they are worried about they're not used to having that level of wealth at their disposal, and they're worried about wasting it all away. And so you can actually set up a trust to put you on a salary to ensure that you do not squander all the wealth that you have gained, right? You can create a trust to meet the educational needs of your children while you are alive as their parent. You can also set up certain clauses in the trust to kick in if you were to become too mentally or physically incapacitated to take care of yourself as a settlor. So usually I have to sit down with people and just educate them on the so many uses of a trust, and correct some of those misconceptions that they have concerning the trust.
Thank you so much, Toy, for those amazing words of wisdom. I'm sure lots of people had a few light bulb moments. Thank you very much for the clarity. I know that you mentioned it and Dami also mentioned it, but I want to throw this question to you, Dami. We always hear that one of the biggest perks of a living trust is to help avoid probates. But what exactly does that mean in real life terms for people that have no legal background? Is it just legal lingo, or does it really save families from stress and drama?
Thank you very much for that question. And before I dive in, right, I would like to explain what probate means, especially for those who might be hearing the term for the first time. So probate is the legal process your family has to go through to validate your will and get permission to manage or distribute your assets after a person has passed. In theory, it's really meant to bring order, but in real life, especially in this part of the world, it often can bring delay. It comes with sometimes court fee, a lot of paperwork, and sometimes family drama. So let me paint a picture, and hopefully it gives us a better understanding. So let's imagine a family where the breadwinner passes away unexpectedly. He has houses. He has houses around Nigeria, a few investment accounts, some savings, but everything is in his name. Now, because such a person only had a will and in some cases, sometimes no plan at all, we see that his family will suddenly find themselves rather in sort of a bind, in a fix. And that's because they would not be able to access his accounts to pay school fees or any other fees or any other bill that might come up. And in some situations, we see where they are not even able to cover funeral costs. And now they have to apply for probate, and this means they fill out forms, they need to get their lawyers, they have to wait for the grant of probate. And in a situation where the estate is contested, or where the will is contested, it could drag on for months or even years. And you see that during that time, everything is frozen. No one can sell the house, no one can touch any of the accounts, no one can really make any decision. And then, just when we think things cannot get more complicated, we hear stories of long lost relatives that haven't been around in 10 years. They just start appearing with opinions, with claims, with entitlements. And unfortunately, right, all of this sometimes can come with the probate process. And in a situation when there's no will, the process of obtaining the letters of administration. And it's not just about the process, it really causes a certain level of disruption, right? And sadly, in my own experience, I've seen families fall apart over it. I've seen situations where siblings who were best friends, inseparable when they were a lot younger, where they stopped speaking to each other because of how things were handled or mishandled after the passing of a loved one or a breadwinner. But now with a living trust, all of this can be avoided. Everything I just mentioned can be avoided, right? The trustee, whether it is a trusted professional or a corporate trustee like us here at Emerging Africa Trustees, we already have the authority over those assets. There's no need for court approval. There's no waiting period, no drama. The instructions are clear, the assets are accessible, and your family can grieve in peace without confusion. So when we say that a living trust helps you to avoid probates, when we say trust helps you to avoid probates, we're not just talking about the legal process. We're not just talking about the law. We're talking about protecting your family's unity when it matters most.
Thank you so much, Dami. I love how you made it practical. It's really not just about avoiding courts. It's about saving time, it's about saving money, and it's about saving stress. I would just like to take the opportunity to please remind everybody to keep their questions coming, and we'll make sure we handle all of them when we get to the question and answer section. I see that we have a few questions right now, but please, if anything resonates with you, if anything looks like your situation, please, please, please keep your questions coming. All right, Toye, let's talk about family drama that Dami mentioned earlier, especially in blended or polygamous families. What are some of the common inheritance issues you've seen, and how can a living trust help prevent them?
So, you know, we've all seen all those Nollywood movies where, money and inheritance is concerned, and people fight and kill each other over land and things like that. Sometimes, life can be stranger than fiction because you can find that actually play out in real life. A lot of what we see on TV is inspired by real life events, right? So again, yes, money and inheritance tends to bring about strong emotions and bring about the worst in people. Usually, when you look at a big polygamous family, there is already some level of distrust, some level of sibling rivalry, some level of animosity already present even before the money and inheritance became an issue. And so when that does become an issue, things escalate, right? So you have situations where children of the deceased are contesting the paternity of their half siblings. They feel that, oh, this certain child, I don't believe that he's actually my father's child, and so I don't believe that he should inherit anything out of this properties, right? So you have those sort of instances. You have instances where family members feel that other family members have taken advantage of the mental, maybe the mental capacity of the deceased, as his testator was growing old, right? Such that they have now obtained a larger share of the testator's assets in the will. So they are contesting that will in court on the premise that mental duress was involved as it concerns the testator, or that the testator was not in the right state of mind, as that when he was bequeathing certain properties in the will to certain family members. You also have instances where, again, because it's a big family, you have a age disparity between certain siblings. So the oldest sibling could be maybe in their 40s, and the youngest sibling is maybe 10 years old, right? Because that sibling is a minor, they might not be able to inherit property directly as it concerns the will. And so maybe some other sibling might inherit it on their behalf, or, it might be expected that the family members would manage their inheritance for them until when they grow old enough. And unfortunately, sometimes, or most of the time, that inheritance may actually be squandered before the child is old enough to take it for themselves. You also have instances where certain family members may be vulnerable or may be mentally incapacitated in some way or the other. And again, because of their special mental needs or physical needs, could be some sort of disability, they are taken advantage of by other family members who are, able-bodied, so to say. So what a trust helps to do is that, first off, the trustee is, or at least is considered to be a neutral party whose allegiance is to all the beneficiaries in total. And so sometimes this helps to reduce conflict within the family because the assumption that the trustee has a perceived bias towards some members of the family is eliminated. The trustee is basically just acting on the best interest of all the family members in total. A trust also provides clear asset distribution instructions for the family. And this is usually done quickly and also done privately, which again reduces the chances of conflict within, the different factions in the family because nobody knows who has collected what, right? So you don't know what you're even fighting about. The trust also manages money on behalf of the minors or the vulnerable adults in in the family, such that they are always taken care of, whether it's medically or in terms of their educational needs or just financially in general. So yeah, that's where a trust comes in to protect, uh, to sort of ensure some level of peace and harmony in a big, blended, big polygamous home.
Thank you so much, Toy. That was very, very insightful, very real. I mean, we all see the movies, but we have to understand that these scenarios actually still happen in real life. There's a common fear to me that putting assets into a trust means that you're going to give up control. Is this true, or is this another one of the myths that keep people away?
First of all, it's a very understandable and reasonable fear. Nobody wants to put their money in someone's hand and not, know what's happening with this. But I have to say it's definitely a myth. A big trust actually gives you more control, not less. So while you are alive and you are capable, you can continue to manage you can continue to manage, use, sell, or even add more assets to your trust. You are still in charge. What the trust essentially does is it creates a safety net. So in case anything happens, maybe you become incapacitated, ill, or anything, there's already a plan in place and your loved ones are protected. You can be rest assured that the trust can be updated to reflect life changes, marriages, birth of children, I mean, even estranged relationships, so these things can be reflected, while you are alive and you can, change and update the trust. So essentially, it's like writing a clear instruction manual for your assets that you can update whenever life changes.
Thank you so much, Timmy. That's a very common worry a lot of people have. And I'm very glad that you've cleared that to be structured. And I also love that you mentioned the ability. And Toye, you also mentioned something about having a revocable and an irrevocable trust. I just want to ask, for the sake of people that have no background, life happens, people get married, divorced, have more children. Can a living trust be updated? Or can you reiterate that a living trust can be updated to reflect these changes and confirm that it's not a one and done document?
So yes, like my colleagues have stated before, like I have stated before, provisions in a trust are not set in stone. Trust, most especially a revocable one, can always be amended or updated to reflect changes in the settler's life or the estate, right? He can choose to remove beneficiaries or add beneficiaries. You can choose to remove assets or add more assets. You can choose to remove certain clauses or add more clauses at any time. during his lifetime as it concerns the trust.
Thank you, Toye, for just reiterating that no matter whether it's irrevocable or revocable change. So coming to you, Dami, there's an idea that you need to be extremely wealthy to set up a trust. Is there an actual like minimum amount of wealth required, or can the average person benefit?
Thank you. That's such an important question, and honestly, I think it's one of the biggest misconceptions I hear all the time. You have situations where people say things like, "Oh yeah, I'm not Dangote, I'm not Otedola, I don't have billions, so I do not need a trust." But here's the truth here: a trust isn't just about how much you have; it's really about how much you care about what happens to what you have. Yeah. So let's say you own a house, even if it's just one, or you have a land in your hometown, in your village, like I believe most of us do. If you've saved money for your children, or you have a small business, and most importantly, if you have people you love and you have people you want to protect, then you already have enough reasons to set up a trust. A trust is not just reserved for those flying private jets or those who own private jets. It's not just for those who manage offshore portfolios. It's valuable for, say, a teacher who has built a retirement home and wants to make sure it goes to her children without any confusion. It's relevant to the market woman with investment savings who wants to ensure that our children's education should continue regardless of what happens. It's essential for an entrepreneur with two rental properties, say in Lekki and a mortgage somewhere in Ikoyi, who wants the rent to support his parents or fund his children's school fees. I remember there's this client that I worked with, a widow. She didn't have vast wealth. All she had was two properties to her name, some saving accounts here and there, a couple of investment accounts, and two daughters that she loved deeply. Her biggest fear was that they would fight over her estate after she was gone. So what did she do? She set up a simple trust and it gave her peace. Not just peace of mind, but peace of heart. And the cost of that trust was less than the stress and expense her family would have had to face going through probate or if she had passed without a plan. So no, and simple and short, no. There's no minimum wealth required to create a trust. The only thing you need is intention, right? Trusts are not, they're not just about status. They're about clarity. They're about control. They're about care. And if you want your legacy to be honored, not argued over, then a trust is one of the most important and most powerful estate planning tools that you can use, regardless of wealth.
That's a very great point, Dami. Thank you so much. It's really good to know that I do not need to wait to be a billionaire in dollars before I can open a trust. Sometimes we're waiting to make it big before planning, when really we can just start small and grow into it. Thank you so much, Dami. Just a little reminder again that if any of this sounds like your family or your business situations, don't worry, we'll take your questions shortly. Just keep them coming in the Q&A box. I see the questions are here. Be rest assured that we're going to answer everything. Okay, so Timmy, would you generally advise choosing a corporate trustee over a family member?
This is a great question and a very real one too. The short answer is it depends on your family dynamics, but here's how I usually explain it. When money, land, or property is involved, even the calmest cousin can start acting different. Sometimes it's not even out of bad intention. They may feel entitled, they may be under pressure from other family members, or they may just, want to get involved in the decision-making process that should be clear-cut. That's why we often recommend having a trustee, someone neutral, professional, and not tied into family politics. A trustee is legally bound to follow the instructions in the trust. If they don't, you can hold them accountable, you can sue them. But when it comes to suing, try doing that with a cousin. It can tear the whole family apart and make you look like the bad person, even though you are just trying to protect your own legacy. Now, if you still want a family member involved, it's okay. You can appoint both a trustee and a family member, like as co-trustees. That way, the family feels represented, and there's also a neutral party keeping everything in check. So, in most cases, for peace of mind, professionalism, and fewer headaches, we recommend having a corporate trustee, especially if you suspect things might get a little complicated later.
Thank you so much, Simi, for that answer. And honestly, even if you do not suspect that things might get complicated, emotions tend to run high when it's time for succession, and having a neutral party is so underrated when things are looking messy. Thank you so much, Simi. So I once read a story on BBC, and this is a bit funny, but it was about a Ugandan tycoon who banned his wives from shaving their heads after his death. So Toye, can a living trust actually include personal and unusual causes like that?
So I haven't heard of this story. But yes, a trust can always include peculiar clauses as it concerns the conditions by which your beneficiaries must meet to continue benefiting from your wealth and your trust estates, right? I believe you can, the sky really is the limit. Your imagination is the limit as it concerns clauses to be placed in your trust for your beneficiaries to follow or for the trustee to follow, as well as it concerns running your estate. I believe that as long as these are not activities deemed to be illegal by the relevant jurisdiction where the trust is set up or where the beneficiaries reside, and there's really nothing, there's nothing you can put in. You have, for example, this recent story of the Nigerian billionaire that stated that his wife, if his wife, upon his death, if his wife were to remarry someone else, then she would lose access to his estate, right? So you can really put in whatever it is that you want to put in, as long as it's not, you're not asking them to commit a crime, right? Then yeah, sure.
Thank you so much, Toye, for that clarity. Honestly, I'm loving how flexible a living trust is, because people are very expressive, and it's good to know that even your wildest wishes, as long as they're legal, can be respected. So Timmy, from your perspective, are there any cultural or legal realities, especially here in Nigeria or let's say West Africa, that can make living trusts more necessary or more complex?
Absolutely. This is such an important question because our cultural context really shapes how inheritance plays out here in Nigeria and, like you said, in West Africa on a broader scale. In many Nigerian families or cultures, especially in the traditional settings, we've seen women completely sidelined or disinherited after her husband passes. And I believe that's where a living trust becomes incredibly powerful. It gives you, the person who feels the breadwinner, the chance to say, okay, this is how I want my legacy handled, not by culture, not by tradition, not by the village elders or whatever the case may be. So with a trust, you set your own rules clearly and legally. You can protect people who may otherwise be sidelined, like I mentioned. In some cultures, I know that women they are not allowed to inherit their father's properties and those kinds of things. So in this situation, you can protect your daughter, you can protect your wife, and in some cases, even adopted children. Sometimes adopted children are seen like, okay, they don't have the blood of the father and what have you, and so they try to disinherit them. So these are the kind of instances that make the living trust powerful. Also, you avoid the assumptions that automatically kick in when someone passes on, especially where there's no clear instruction in place. Now, yes, setting up a trust may seem new or foreign to some people, but actually it fits our reality very well because of the sometimes complicated family dynamics that show up. And honestly, the earlier you set it up, the better, before any drama can even begin. So in a nutshell, living trust helps you rise above some of those cultural noises and protect your legacy the way you intend to, and not how people choose to interpret it after you have passed on.
Thank you so much, Timmy. Thank you very much. What you said was so important, especially about women being sidelined when it comes to inheritance. I don't know if you saw the story about the Nigerian filmmaker, her name is Onye Igwe, who shared that after her father died, her brothers took everything and left her with absolutely nothing. No documents, no voice, just silence, simply because she's a woman. It's very painful, but it's also so common in our society. You see how culture, patriarchy, and poor planning all come together. And it's people like Onye who suffer the consequences. That's why what we're talking about today, these are not just legal tools or paperwork. And these are not just paperwork, they're protection. They're protection. Thank you so much, Timmy. I would just like to remind everybody again to kindly put up their questions and we will be taking them shortly. Also, in a few minutes, our poll will be live and please just take out a few seconds to answer so that we can serve you better. That's all we want to do. We want to serve you better. We want to know where you're at and we want to make sure we provide all the necessary tools that you need. But now let's put decision and what are the key things that people should consider when.
Okay. I mean, I'll say this particular question, sorry, really hits close to home because I've seen what happens when people get it wrong. First of all, I just want to mention that your trustee is essentially the engine of your trust. They're the ones that keep it moving even after the settlor has passed, and or in a situation where the settlor, for some reason, is unable to manage things himself. And yet, many people just pick, say, a relative because they are older or responsible or a friend, best friend, as the case may be, without thinking of the long-term risks. I've had to handle a case before where a man made his younger brother the trustee. If I'm correct, the age gap between him and his younger brother was 20 years. So he expected his younger brother to live even longer after he passed. And at first, everything was fine. Things were going smoothly. But after he passed, the brother started doing things in his own way. Yeah, we saw instances of where he gave out where he sold family land rather, without consulting the children. And eventually, the family had to take him to court. And that's why I say that it's always important to separate sentiment from stewardship, right? It's not just about love, it's about trust, it's about accountability, it's about structure. Having a corporate trustee, like ourselves here at Emerging Africa, it comes with an extra level of care and the fiduciary duty. We are bound by law and our professional ethics to follow what is contained in the trust deed, right? And the trust deed is essentially the one document that contains all the intentions of the settlor and also covers the assets that will be kept in trust. With us as a corporate trustee, right, we do not take sides. We do not spend trust funds without approval. We are neutral. We have a proper structure. And most importantly, we are present when others are not. What do I mean by that last statement? As a corporate entity, we enjoy what we'll call perpetual succession, right? That means regardless of what happens, what changes, we will still be existing. So in a situation where I just stated, where the man passed, let us say in an instance where his brother had also passed, his brother being the trustee, and there were no more trustees, the family would be in a bind where they might need to go to the courts to appoint another trustee and whatnot. But having a corporate trustee from the get-go, that means that regardless of whether Dami Olubemi is here today or not tomorrow, your trust is still going to be properly managed by the corporate trustee, in this instance, Emerging Africa. So I would say that if your goal is peace of mind, then choose a trustee that will preserve and not destroy that your peace of mind. Thank you.
Thank you so much, Dami. The person or the institution that you appoint as your trustee becomes the anchor. So it's not a small decision at all. And I love how you were able to break it down. Please, I just would like to announce that the poll is now live. Just take out 30 seconds, 1 minute to fill it out so we know how to serve you better. And also, please keep your questions coming. I see them in the chat box. I see them in the Q&A, and we will definitely answer as many as we can with the time given. Okay, so Toye, for someone that's considering setting up a trust, what's the actual step-by-step process, especially here at Emerging Africa Trustees? And when would you say is the ideal time to get started? Toye, please, could you unmute your mic?
Apologies. Okay, so yes, so if you have any assets that you wish to, if you have a family, if you have any assets that you wish to, manage or protect on behalf of your beneficiaries, then really there's no more ideal time than the present, right? So as soon as possible, possible to at least sit down with a trust firm and look at setting up a trust that covers those assets and protects those assets on behalf of your beneficiaries and also on behalf of yourself. It's important to note that you can be a settlor, but also be a beneficiary of your trust as well. And like I've said, like my colleagues have stated, you don't have to be multimillionaire or millionaire or billionaire to set up a trust, right? The actual step-by-step process, usually we would, again, we would have like an interview process where, you would sit down with the trustee and we would get a sort of idea or the scope of the assets that you currently have. The size of the assets, the type of the assets, are they shares, are they stocks, are they real estate, and then the goals that you have as it concerns your, the management of your estate and the protection of your estate. What do you want to achieve with the trust? Is it with respect to privacy? Is it tax optimization? Is it legacy? Is it succession planning? Is it all of these things combined, right? And then, based on that interview, we can sort of give like a rudimentary or a skeleton trust structure as to how, and our recommendations as to how to structure that trust for you. And then we would also look at, having a meeting with other third parties to be included as it concerns, setting up that trust. So, for example, you might be having a meeting with the tax advisors or maybe accountants that might also be responsible with, helping to structure your trust. At this point, we would also, what's the word I'm looking for? We might also sit down with other trust funds because sometimes you have clients that have assets not just in one jurisdiction, but in other parts of the world as well. So we might look at other co-trustees who might help with creating a trust that encompasses all those assets across those different jurisdictions. We would also be looking at, the KYC process, right? Know your customer. So we would, just in terms of fulfilling our compliance obligations, we would want to get information as it concerns your source of your funds. At this point, we would also be drafting the trust deed. A trust deed is basically the document that governs how your trust is managed, right? And so we would draft it and we would also send it off to you for your review. And then we would, go on to execute the trust deed. Once we have spoken with you, and once we feel that this is the final draft of the trust deed after reviews by the trustee, the third parties, and also yourself as a client. And yeah, I believe that's about it, really. I don't know if my colleagues want to add, but I believe those are the necessary steps to setting up a uh, trust structure.
Yeah, thank you very much, Toye. I would say everything you said is in line. I would just like to add. So after the trust has been set up, we have an ongoing responsibility to administer, monitor, and report on the trust. So administer comes in form of having to make disbursements, be it school fees payments or rental income towards the beneficiaries, or whatever it is that has been stated in the trust deed for us to do in terms of administration. Then we also have a duty to invest and manage those funds accordingly, or the assets accordingly. And finally, depending on what the settlor wants or the structure of the trust, there's also an ongoing obligation to report performance of the trust assets. Yeah, that's all I just really wanted to add there. Thank you very much for that, Toye.
Thank you so much, Dami and Toye. That was very clear, very practical. I think a lot of people will be surprised at how structured but approachable a living trust actually is. Again, thank you so much for the questions so far. I see all of them. We're going to get to them, but just continue to send in your questions and we would get to every single one of them, or as many as we can with the time given. Timmy, so over to you. What are some red flags that our audience should be aware of when picking out a trustee or setting up a trust?
Okay, there are a couple of these actually. One major one is setting up the trust and then forgetting about it. Because life changes and these changes need to be reflected in the trust. However, if you don't go back and update the trust, it can become outdated and even cause the exact confusion you were trying to avoid in the first place. So the major thing is setting it up and forgetting about it. That's a red flag. Another red flag is choosing the wrong trustee. And this is very crucial because this is the person or institution that is going to be managing your assets and carrying out your wishes. So if you pick someone who lacks integrity or who doesn't really understand the role, that's a recipe for disaster and possibly even legal battles or disputes. So it's not just picking about who you like, it's about picking who is capable and trustworthy. Also, people sometimes leave important things out of the trust. I mean, like I mentioned, life changes and all that. But sometimes, like a new piece of land that you acquire, or maybe you get an investment account, those are the things that need to be listed clearly or transferred into the trust. Um, Otherwise, it will not be legally covered, and the family could still end up in dispute over it. And another big one is trying to DIY or do it yourself, a trust without proper guidance. I mean, because we're in the technological age and a lot of templates are online. So sometimes people feel like, okay, I mean, I have the template, I can just go ahead and do it for myself. And we really say that you need to have a lawyer, someone who understands the role and who is capable of doing these things. Otherwise, if you copy the template online or you have a lawyer who doesn't really understand how it works, when the time comes, the trust only creates more confusion than clarity. So please don't wing it. Get proper advice. At the bottom line, don't treat the trust like a one-time task and forget about it. It's something you should review from time to time, especially after major life events, and make sure you get support from people who understand how it works, like we here at Emerging Africa Trustees. And that's what helps the trust actually work when it matters the most.
Thank you so much, Timmy. That's really helpful. Sometimes it's what you don't know that's going to cost you. And I know that the advice that you just gave is going to save someone a lot of headache. All right, now that we're about to wrap things up, if there's someone listening right now thinking maybe I need a trust, what's this one simple practical step that they can take immediately after the session? Let's start with you, Dami.
Thank you so much. And I would say I love this question because it brings everything we've said down to one simple, doable step. And if you're listening today and you have never thought about setting up a trust before, Here's where I suggest you begin. Start with clarity. Try to establish clarity. How do you do that, right? So you could just take out your phone, open your notes app, or if you want to be a traditional person, you could grab a pen and paper and write down these things. So the first thing I would like you to do is to ask yourself this very simple question: what do I own? In answering that, it could be landed property, it could be a house or flats, it could be stock holding, shares, investments in different brokerage homes, a savings account, it could be jewelry, big or small, just list it, anything that is precious to you. Now, the second thing you do is you ask yourself, who do I care about? Think of your spouse, think of your children, think of your siblings, your nephews, your nieces. It could even be parents that you support, or it could just be a cause or something that you're very passionate about. Then finally, you should ask yourself, what do I want to happen if I'm no longer here tomorrow? And that's it, right? You do not need to have all the answers today, but that simple act of listing those three things will help you realize one thing. It will help you realize that you actually have more to protect than you actually think you do. And from there, reach out to us. Reach out to us here at Emerging Africa Trustees. Let's have a conversation. Whether it's a living trust, an education trust, or a charitable foundation, we would help you create a structure that fits your values, that fits your assets, and also goes along and aligns with your goals. And please, like I mentioned earlier, do not wait until you have billions. Trusts are not for when you blow, like we say. They are for when you care. And like I always say, even if it's a modest plan, as long as it is done early, it is by far better than a massive estate without direction. Because the truth is that, yeah, it's not just about your wealth, it's about your responsibility, it's about peace, and it's really about leaving behind not just your assets, but leaving behind a legacy, and a legacy that is surrounded by order. Thank you.
Thank you, Jami. I see a hand raised. Thank you so much for wanting to be a part of this conversation. Please just keep your question in the chat box and we will get to it shortly. Timmy, do you have any advice for anybody thinking that they want to set up a trust? What's the practical step you can give?
My colleague has really he has really done justice to it, but I'll still take out of some of the things that he said. I would say, start the conversation, don't overthink it, just act now. You don't have to have it all figured out today. Simply make the decision to take that first step, whether it's asking a question or speaking to a professional like we at Emerging Africa, or even reading a little bit more about how trusts work. The important thing I would say is to move forward, forward from thinking about it and actually doing something. So no matter how small, taking action, even that first step, that first little step is crucial in making progress and moving forward. So act now.
Thank you so much, Timmy. And lastly, Toye, we would really love to hear from you. What's that advice you would give to somebody looking to set up a trust?
Again, like has been stated by myself and my colleagues, a lot of people think that they have to be within a certain tax bracket, you need to have a certain portfolio before you can set up a trust, but that could not be further from the truth. Um, a trust can actually be an effective tool in creating wealth for yourself rather than waiting to be wealthy. The trust can be something that actually helps you to attain that wealth because you have, financial experts, you have wealth managers that are looking after your assets, but are also looking after you as the settlor and also your beneficiaries as well. So again, the best time is, today. Second best time is tomorrow, as it concerns setting up a trust for yourself. So yeah, I think again, when you also look at the economy, you look at inflation, you look at naira devaluation, those are sort of things that a trust can help to protect you from. you're looking at generational wealth, looking at creating generational wealth, a trust can be something that's beneficial for you in that avenue. And yeah, I think that's about it from my own end.
Thank you so much, Toye. I really love what you said. The best time is today. And if you're not able to today, start tomorrow. Very solid advice from all of you. Thank you so much for the insights. Thank you so much for taking out your time today. Now it's time to hear from our audience. If you have questions for Dami, Timi, or Toye, whether it's about structuring a trust or choosing a trustee or navigating family dynamics, please go ahead and drop them in the Q&A box and we'll take as many as possible. Before we go into the Q&A box, though, I see some questions in the chat room. So we'll start. We have a few in the chat room. We'll start there. So, okay, Dami, I think we will start with these questions to you. Sanyambe says, so far, all presenters on Will and Trust have not addressed the issue of when do you write or develop it while you're having a moral hazard or while you're alive. While avoiding a moral hazard while you are alive. Dami, can you hear us?
Sorry, I was struggling with unmuting myself. So yeah, thank you. I think that's really important, and it's an often unspoken, unasked question. Many people worry that if they create a will or a trust while they are still young, active, and in control, it might, to a certain extent, encourage entitlement, dependency, or even manipulation from the people that they intend to benefit. I mean, I've heard stories of people actually committing a sort of fraud and even murdering people so they can benefit off the trust or the will, as the case may be. And to be honest, it's a valid concern. And that's exactly why timing isn't the only issue, right? Structure and discretion are just as important. The right time to create a trust, as my colleague has said, it was yesterday, second best time is today, third is tomorrow. And it's why I would say now is because it's good to do it now while you are still sound of mind, while you are still able to think clearly, able to plan strategically. And the key is to structure it in a way that protects your values and not just your assets. So let me give some examples, right? In a living trust, you can appoint a neutral trustee, like a corporate, to hold discretion over when and how assets are distributed. So in that kind of situation, right, the trustee has that discretion. You avoid that moral hazard. Secondly, you can set conditions for access, like an age milestone. I've seen trust structured in a way that the beneficiaries cannot have access to the benefits until their 28th birthday, or in some instances until they get married. It could be some educational achievements, like I believe Toye mentioned earlier about getting a PhD or something like that, or even personal development goals. And we can also, in a trust, decide to hold back the benefits in stages. So just you get to milestones before you're able to access some parts of the estate or some benefits from the estates, and rather than just enjoying everything at once. And what this does is that it allows you to avoid that moral hazard, that because you are not just handing out gifts, right? You're not just handing out gifts. You are guiding how those gifts are used, even in your absence. So it's also worth saying that, and I think this is very important, silence is not necessarily a strategy to avoid these moral hazards, right? Avoiding the conversation because of fear doesn't really remove the risk. To some extent, it might even increase the risk, because when there's no plan in place, the people left behind are left to guess your intentions. And that is when moral hazard and manipulation and family disputes can thrive. So yeah, like I said, the best time to develop your estate plan is when you are clear-headed and forward-thinking. And the best way to avoid moral hazard is to use the structure of the trust to reflect your values and not just your wealth. Thank you.
Thank you so much, Dami. Thank you very much for that answer. Next, we have a question from Ejay Kese. Antoya, I'm going to throw this back to you because you answered it in your speech. You said, hello, everyone. It's been an insightful session. What's the process of setting up a trust, please? He joined pretty late, so we have to forgive him for taking us back to this question. So Toye, please, would you please briefly explain to us the process of setting up a trust?
So usually the 3 to 4 steps, right? The first step would be for you to, sit down with the trust experts, to give them information on, the assets that you have, the assets that you wish to put under the trust. What type of assets are they? Are they, is it real estate? Is it shares? Is it stocks in certain companies? What's the size of these assets? What's the location of these assets? Do you have assets just in Nigeria alone, or do you have assets in different parts of the world? We have clients, for example, that have assets in the UK, UAE, US as well. We also want to look at, what are the goals? What do you want to achieve with the trust? Usually when it comes to a trust, there are 3 or 4 goals that a client might have. So, is it tax optimization? Is it legacy building? Is it privacy? Is it, succession planning? Is it, generational wealth, right? So we would look at what are your desires, and based on that information that is provided to us, we can then make recommendations to you as to how your trust should be structured, such that it meets the goals that you set out for it. Part of that also involves getting third parties on board. So, for example, if your goal is tax optimization, and you have assets not just in Nigeria, but you have assets in different parts of the world, we might want to get, tax advisors that would ensure that, the trust structure that we're building is in compliance with certain tax legislations in those different parts of the world, such that, you are able to get the best tax benefits for you. And then also we might look at speaking with other co-trustees, because again, depending on the size of the assets that you want to put under this trust, and depending on the location where you want to put this trust, there might be other trust houses that we might need to get on board, right? Such that we are able to create an umbrella trust that works for you. Also, we might need to look at other transaction documents that might be needed as it concerns your trust. So one for sure would be the trust deed. So we would, draft one, we will send it out for you to review it. We would make sure that it, falls in line with all the necessary compliance and regulations. Also, we will be looking at KYC documents as well, because again, acting in compliance with, the relevant provisions, we might need to know the source of your funds, right, to ensure that we are not engaging in, money laundering or terrorist financing by creating a trust structure for you. We might also be looking at things like FATCA, right? So we have clients who might have assets in the US or might be Americans. So they might have dual citizenship. So they are, not just Nigerians, but they're also Americans as well. So we'll need to make sure that we actually are acting in compliance with, FATCA, that's American tax provisions as well, as it concerns, your trust assets. And then, once we are able to finalize on, we might need to have meetings with those third parties, with the clients, present as well. Once we're able to finalize on all these things, then we can set up the trust structure for you. We might also, obviously, once that is done, you then have the final process, which is for us to continue administering and monitoring your trust in line with your goals, right? And so by administration, what I mean is, for example, as it concerns payment of children's school fees, as it concerns maybe the maintenance of certain real estate properties. Also in terms of maybe, like we had already said before, you can delete or add things to the trust. So with the trust deed, we can always, have yearly meetings where we sort of discuss what amendments you wish to make to your trust, whether you want to revoke certain clauses or you want to add more clauses or take out certain beneficiaries or add more beneficiaries. So yeah, I think that's really how it works.
Thank you so much, Toye. Thank you very much. That was very insightful, and I hope that had cleared it up for you, Eje. We have quite a number of questions in the Q&A, and I'm going to try. I really would like for us to take as many of them as possible. So I'm going to just skip over the ones that we have already mentioned, maybe in the answers, and just go to the ones that we have not spoken about. So this one, I think it should be to you, Dami. You mentioned earlier that privacy is a major benefit of using trust. Could you expand on that a bit? How does that play out practically in client setups?
Okay, yeah. Yeah, so yeah, absolutely. Privacy is one of the I would say overlooked or one of the most important advantages of using a trust, yeah. Especially in environments where if a person passes, everyone suddenly becomes interested in who got what, right? So with a will and with passing interstate, right? Sorry, let me go back to where rather. With a will, right? After it has gone through the process of probate, it becomes a public document. And what does that mean? It means that anyone can go to the probate registry and request to see the contents of the will. It also means that the family's finances, the beneficiaries, and even internal tensions may become a part of official public record. I mean, from the from my city room, I've heard of stories of families that are fighting over the content of a will, right? But with a trust, there is no probate. Very important. And that means that there is no public discourse. There's no public disclosure. The distribution of assets or the enjoyment of the assets are enjoyed and it happens privately. It happens quietly and it is done according to your exact instructions. So we have seen clients, especially high net worth individuals or public figures, who do not want their estate plans to become newspaper headlines or spark gossip in the tabloids. And with a trust, you are ensured that only the trustee and the relevant beneficiaries know the details and the rest of the world stays out. So it's not just really the secrecy or the privacy, it's trust being used to maintain dignity, discretion, and also creating protection for the people you care about.
Thank you so much, Dami. Timmy, I'm going to throw this question to you. We've been a bit quiet. Given how fast wealth changes in Africa through startups and crypto, are trust companies adapting their services to meet the client's profile?
That's a very crucial question, especially because we're in the age of technology and things are advancing almost at the speed of light. So I would say yes. And it's a good observation because today wealth doesn't always come from land and buildings and physical property anymore. Especially in Africa with our, teeming with youthful population, we're seeing a younger generation build serious value through startups where you may own equity or shares that can be passed on, crypto and other digital investments, and even online businesses and royalties, including content creators, tech freelancers, and such. So modern trust companies, especially the progressive ones, are now updating services to help you include digital assets like crypto in your trust, recognize the non-traditional assets that younger people are acquiring now, and also structuring trusts to also handle things like startup shares, like NFTs and intellectual property rights and the such. So whether your wealth is traditional or digital, the goal is the same for we as trustees to protect it, to manage it properly, and to help you pass it on according to your wishes. And yes, the trust world is actually catching up to reflect, the technological realities that we are seeing today.
Thank you so much, Timmy. There's a question here, Toye, I would love for you to answer because it's a very important question. So it says, what happens if your company places funds in a financial institution that goes into liquidation? How do they administer the affairs of the estates when the funds are locked?
Okay, so usually if I'm trying to understand the question, who has placed funds? The settlor has placed funds in a company that has gone into liquidation. Is that the question?
Yes, that's the question.
So if a company goes, into bankruptcy, I believe that usually one of the first things they do is to then declare that bankruptcy. And then, the company is then put into a state of, I think, receivership, right? And then the job of the bankruptcy agent or the receivership is to now, sit on the board of the company to look at the assets of the company and look at how, the shareholders or, creditors, right, to that company can receive, if not all, at least a sizable portion of the money that they have put into the company. Usually, I believe the creditors are usually the first people to receive money before the shareholders, right? So usually the receiver will look at selling off, whatever assets that can be sold off. Usually, sometimes they might even try to what's the word I'm looking for? Reverse the issues with the company. If the company has, if it's not, if the bankruptcy is as a result of mismanagement, for example, they might look at trying to reverse the turnaround of the company. But if that is impossible, then they might look at selling off assets owned by the company to then pay off, the debts. So, for example, that person that has, invested money or that has, lent money out to the company would be one of the people that will be in line to receive the funds after the sales of the assets on the as it concerns the company. If such a person were to have a trust, then the benefit of that trust would be that they would not have to be the ones pushing the process. They will not have to be the ones applying and running around to ensure that they get their money. The trustee would be the ones doing that on their behalf. So that would be the benefit of having a trustee. And then, of course, if it's a trustee that is, a reputable one, if it's a well-established one, they would have, relationships that could also help them to ensure that you as a creditor get your money in time. And then, of course, even if you were to pass away, you can be rest assured that your beneficiaries, the trustee would still be acting on behalf of the beneficiaries to ensure that you get that money that is owed to you from that company that has gone into liquidation.
Thank you so much, Toye, for clearing that up. Olusegun wants to know, and Timmy, I'll direct this question at you. Can I set up a trust myself, or do I definitely need a lawyer?
I mean, technically, yes, you can set one up for yourself, but here's the truth. A trust is a legal instrument, and if it's not done right, I'm sure we can all appreciate that it creates more problems than it solves. So, for instance, just imagine this. Imagine you're trying to fix your car engine by yourself by watching YouTube videos. It's doable, but it's risky. So, a trust might look simple on the surface, but small errors in wordings and details or structure can make it unenforceable. It can leave out key assets. It can even confuse your trustee or even the beneficiary later. So even if you are someone who loves to do things by yourself, I'd still strongly recommend working with a lawyer or a licensed trust company. And I have to picture ourselves again, emerging Africa. Even if it's just to review what you have prepared. Also, a trust company can help make sure your assets are actually transferred into the trust, which is a step many people forget when they do it on their own. In short, don't wing it with your legacy. Get professional help, especially for something as important as this.
Thank you very, very much, Timmy. Dami, I'm going to throw the next two questions to you. Just because of time, I'll merge the two together. So the first one is pretty sensitive. The person says, how do I bring up the topic of trust with my family without creating tension or making them think I am dying soon? And right after that, I would love you if you answer what the financial implications of trust, starting over trust is. Is it an annual fee or is it a once for all bill?
I'll take the first question, but I would actually ask you to repeat the second question. So for the first question, right, how do I bring up the topic of trust with my family? So I always smile, right, and because this is such a common concern, and I smile when people ask because it really reflects our reality, right? In many African homes, and from a lot of conversations I've had, talking about estate planning really feels like calling bad luck. Some people might think that they are using that to attract evil or bad luck. But I always advise clients, right? Frame the conversation around responsibility, not morality, not not around anything except responsibility. And you can say something like, I want to make sure things are in order, not because I'm expecting anything to happen, but because I have worked hard and I want to make life easier for you, not harder, right? So you need to couch that conversation in a way that your beneficiaries understand that what you are doing is not because you think something is wrong, but you want to ensure that everything is in place, right? I want to make sure things are in order. You can bring up like real life examples, right? Off the top of my head, I'll just say this. Remember that family that fought over property in Lekki? Yeah, I want to avoid that. The more you position it as protecting the family instead of planning for death, right? The more open and constructive the conversation can become. So long and short, just really couch it around protecting the family, protecting your legacy. Yeah, and I think that will make the conversation a lot easier.
Thank you so much, Dami. For the sake of time, I would like to just ask my amazing speakers to please, let's try to keep our answers concise because we still have a number of questions to run through, and I would really love that we get through everything. So the second part of your question was actually, what is the financial implication of starting a trust? Is it an annual fee or is it a once and for all bill?
Good question. And to keep it simple, there are two types of fees, right? There's the setup fee, and this is a one-time cost for drafting the trust deed and registering the trust. Again, this comes with, it depends on how complex the trust is. And then we have an ongoing annual administration fee. And this really covers the ongoing work of the trustee, including and not limited to managing of assets, disbursements, reportments, and compliance. Again, we consider the fees on a case-to-case basis, really just looking at the size of the assets to be held in trust, the scope of work, and the purpose of the trust. Yeah.
Thank you so much, Dami. Toye, so I have a question for you. So the question says, am I right to say that in a trust scenario, the trustee is not obliged to disclose the benefits of the other beneficiaries to a beneficiary, this giving total protection of information on the settlor's decisions?
The trustee is not obliged, and you can specifically set it out in your trust deed that the trustee has no duty to any sort of duty to disclose how the assets are being managed to any of the different beneficiaries. You can set it in such a way that it sort of exists in silos, and so the only thing that should be disclosed to your beneficiary is asset distribution that concerns that beneficiary, that specific beneficiary, right? And that sort of prevents conflicts between all the different family members because nobody knows for sure what anybody is getting, right? So yeah, you can set it up in such a way that you know, yeah, you can also set up, you can also have an NDA agreement as well with the trustee, such that, again, I mean, even though, to be honest, your trustee already has a duty of confidentiality as it concerns you, the client, but you can set up extra layers to just ensure that, what is, happening in the trust stays confidential, even as it concerns the beneficiaries in the trust.
Thank you so much, Toye. So, Timmy, over to you. This question says, how do I know if a trust is actually working as intended?
That's a practical question. I guess because setting up a trust is one thing, and making sure it's actually working, is actually doing what you wanted it to do is just as important. So, I would say the most, I think the best way to know that it's working is that your assets are properly transferred into the trust. That means, for example, your house title or your investment accounts have officially moved into the trust name. But if your assets are still in your personal name, then there's a good chance that the trust isn't active. It's just on paper. Another way is if your trustee is like actually understands and is following your instructions. And in this instance, I would say this could mean the way the trustee is handling school fees for your kids, or managing your business, or even holding land until a certain age. This is another way to actually tell that it's working. Also, if the beneficiaries are clear and they are being taken care of, there's no confusion or disputes arising from it, then you can confidently say that the trust is working as it should. And also, like I mentioned earlier in the conversation, that once you have reviewed and updated it over time as life changes, then you can be sure that it's working the way it should.
Thank you so much, Timmy. So we're about to take our final question just because of time. It's a Monday morning. We would love to let all of you go back to what you have to do today. But this question has come up a couple of times in the Q&A and in the chat box. So Dami, please, could you please answer, what documents do people need to gather and what decisions they need to make before setting up a trust?
Okay, excellent question. And honestly, it's a bit more straightforward than most people like to think. So for one, you'll need a list of your assets, so land, properties, accounts, shares, businesses, jewelry, whatever it might be. Then a list of your beneficiaries. Who do you want to benefit from your estate, or what do you want to benefit from your estate? Segue, I saw a story of this wealthy person in Germany that left his assets to his dog. So yeah, that's funny. Just thought to share that. Then you'll now need copies of basic documents, right? Like your means of ID, utility bills, sometimes your land or title documents, just things to prove ownership of the assets that you claim to have. And finally, most importantly, you need a clear sense of your intentions, who gets what, at what age, and any special conditions. From there, us, as the case may be, your trustee, will be able to help you build out the structure that reflects those intentions. And then we'll just essentially take it from there.
Thank you so much, Dami. Thank you very much, our amazing speakers, for breaking down what can often feel like a very complex topic and making it very practical and relatable. Thank you very much to everybody who joined. If there's one key takeaway from today's conversation, it's that you do not need to be a billionaire to plan intentionally. A well-structured living trust can help you protect your legacy, reduce future conflict, and ensure that your wishes are honored. Again, to everybody who joined us, thank you very, very much for taking our time. We hope that you found this session helpful. And as always, if you have any further questions or you need support, please reach out to us at our team at Emerging Africa Trustees, or you can reach out to us on all social media platforms. Our name is Emerging Africa Group. That's across LinkedIn, Facebook, Instagram, Twitter. We are Emerging Africa Group. But if you want to reach out to the trustees team directly, please send an email to trustees@emergingafricagroup.com. That is trustees@emergingafricagroup.com. So thank you. Until next time, plan wisely, protect intentionally, and preserve peace. Have a beautiful day, everyone.
Thank you, everybody. Bye-bye.
I wanted to add to Milene's response. I don't know if it's too late already, but as it concerns whether the trust is working or not, again, as the settlor, you will be involved in the build-up of the trust, so you're able to, see whether the trust is working or not, because you'll be there involved while you are alive. And then, of course, depending on the goals that you have, you can evaluate whether you feel that the trust is meeting those goals. That would be a clear indicator of whether the trust is doing what you think the trust is doing. You can also appoint a protector as well as it concerns your trust to ensure that everything that you've set out in the trust is actually being accomplished or is actually being done. So yeah. Okay. Thank you, everyone. Apologies.
Thank you so much for adding that. Thank you, Tui. That was amazing. Thank you. So again, everybody have a beautiful day. Bye.
Bye.